Alex here with a high conflict child custody video on right to know where child resides. This is a video that I was kind of surprised I didn't do, since the case I was published on, Falcone v. Secretary of State, actually is exactly on this topic, but I ended up talking about it so many times in so many different videos. I guess that's kind of why I spaced covering it in its own topic, but I did get a couple of questions recently that made me realize I should probably cover it. So yes, parents have a right to know where their child resides, whether you're the mother or the father. This is a little complicated in the modern era of restraining orders, also known as orders of protection against domestic violence. You have people, and this is quite common now, that come into court and say, my ex is dangerous, I don't want him to know where I live, I want to keep my address a secret. And this is exactly what happened in my case. What happened in my case was that my ex didn't want to let me know where she lived. And in the beginning of the case, I didn't push it too much because she was really alleging that I was a stalker, that I was dangerous, that I committed domestic violence against her and stuff. She sought out a protection order after I sued her for child custody and visitation many months, many months after we'd been split up. And so the family judge didn't really buy it. In fact, when it came to rendering his initial decision, which was in part based on settlement conference and in part based on a lot of back and forth, false accusations, delay tactics, and all that nonsense. He didn't even discuss it at all. I mean, and neither did my ex's attorney. It was odd. It was like she brought it up, or I mean, at least my ex's attorney brought it up for the order of protection against domestic violence, and once that was issued, during the child custody case, she never brought it up again. And that does come out in the Supreme Court publication. The justices of the Supreme Court, specifically Justice Cherry, authored the opinion, and he did note in I can't remember if it was a footnote or if it was in the substance of the publication, that he found it odd that my ex never brought it up. It wasn't even brought up at all in the child custody case. Yet later on, I can't remember how far into the post-judgment process, probably around a year, when I filed my motion to have my ex forced to disclose where she resided, all of a sudden the domestic violence was an issue again, and she used the domestic violence order of protection to get a fictitious address for from the Secretary of State. Now, the reason this is relevant, and this is actually becoming a little bit more known in Nevada. My case hasn't been published for 5 years now, and a lot of the judges starting to have read about it and used it in their cases when this comes up. What's starting to happen, at least in Nevada, is when a victim claims they need to have their address kept secret, the judge will typically state that you have to turn it over because, you know, such and such has a right to know where his child resides. And it's usually in the context of the male abuser, female victim. Of course, it can be the other way around, but just bear with me on that. You either turn it over within a certain amount of time. My judge ordered my ex to turn it over within 30 days, or apply for a fictitious address from the Secretary of State's confidential address program, and that's in line with the Falcone v. State publication. I'm going to go ahead and post a link of my publication down in the comments below, and I'll probably put it up in a card so that anyone here who wants to read about it can go ahead and click on that link and read it. I'll go into it in more detail towards the end of the video, but anyway, they basically issue an ultimatum to force the person claiming that they need to keep their address secret to either or turn it over because they have no right to keep it secret, or go and get a fictitious address from the confidential address program. My ex obviously doubled down and went and got the fictitious address from the confidential address system, and then she turned over that fictitious address to me, which is it's worthless. I don't know where my kid resides if I have a fake address. Just so people know what it is, a fictitious address in Nevada, at least, and I'm sure the other states are very similar, is an address that it looks real to anyone who looks at it, whether it's just some random person or like the power company or a phone company, whatever. You can put it on whatever you want to, lease agreements that you're signing, stuff like that. Looks like a real address. It's in Carson City, at least in Nevada it is. It's in on a street called Roop, R-O-O-P. I'm not sure if the whole street is fake or if it's just a building. Honestly, I think there is a building, like it looks to be like some kind of very small apartment I don't even want to call it a quad because it looked like it had more than just 4 rooms on it. And it looks like there's a few rooms that are they're just there to collect mail, and the Secretary of State uses them. Just makes it appear like a real address, but it's really not. It's supposed to be to help victims of domestic violence hide, yet at the same time give them a physical address that they can give to, like, people who want it, like a landlord or a company that they're contracting with. So anyway, in my case, my ex doubled down and got the fictitious address. Now in Nevada, I'm not sure about all the other states, it's kind of complicated, or at least it was before Falcone v. Secretary of State was published. There were 2 different statutes in the same statutory scheme. The first statute said that a victim had to prove that they were actually, a victim of domestic violence. Not that it was a possibility, not that it might one day happen, but that it actually had occurred. But there was another statute inside of that same statutory scheme that said that any of the following items in this list, if produced to the Secretary of State, would require the Secretary of State to issue the fictitious address to the applicant. Now, mind you, this is just an application process. This process it's not really like a court process. It's not an adversarial process. A person just goes to the Secretary of State's confidential address program, fills out an application, turns it in, and either gets their address or it's denied. So they're not getting any input from, like, say, an ex. So it's almost as if the legislature really, and use the word ignorantly did not imagine that maybe somebody might use this program to abuse, somebody might abuse this program to frustrate their ex's parental rights. Maybe, just maybe, somebody would lie and get a fictitious address and just go, haha, now you don't know where I live. It happens in high conflict cases, and it's what happened in mine. Anyway, one of those items listed in that list was a protective order. And the Supreme Court of Nevada discussed this in that opinion. It's not clear as to whether or not it's an extended protective order or whether or not it's a temporary protective order, which is granted ex parte, or whether or not it matters that the order is currently active, or whether or not whether it's okay that the order is expired. And in my particular case, my ex used that old order that was expired to justify getting the confidential address program. I don't feel like I've gone off course here. I feel like I've just given a lot of details, so I'm going to try to stay on course, I guess, and cover the publication. So anyway, the way I dealt with it, the way I challenged it, was initially to say that there is a conflict in the statutory scheme because one of the statutes requires something from a list, which in this case is a protective order, and the other statute states that the person has to prove that domestic violence has actually occurred. Now, I realize now that I haven't quite explained why this is a problem. For those people that don't know, you can watch my video on, I think it's called restraining orders or orders of protection, something like that, where I explain that orders of protection must be issued if a person demonstrates the potential for domestic violence. The potential for domestic violence will get a person an extended protective order. They do not have to prove that you have actually done anything to them. They just have to prove that something might one day, possibly, maybe happen. That's the problem. That's the issue that I raised that's the issue that I brought to the attention of the Supreme Court of Nevada. The issue is that my ex used a protection order which only required a potential of domestic violence occurring. I also alleged correctly that at the temporary protective order hearing, no evidence was substantiated to show that I had done anything because I hadn't done anything. And that was not consistent with the other statute that required domestic violence to have actually occurred. That the fictitious address program was for actual victims, not just people who said something might happen one day, maybe. So the Supreme Court agreed with me, but not in the way that I brought it to their attention. I initially argued that the Secretary of State should be commanded to exercise discretion and determine whether or not an applicant actually has been a victim. And the Supreme Court of Nevada disagreed with that specific argument, but did agree with me that I had a fundamental right as a parent to know where my child resided, and that therefore, since I had a fundamental right, and since the Secretary of State did not have the authority to exercise any discretion, that I would be able to get somebody to exercise discretion, just not the Secretary of State. And they decided that that somebody would be a district judge. So in Falcone v. Secretary of State, they basically took a procedure that was created in New Jersey and adopted it into Nevada's case law, basically. I'm skipping over a lot of the details. They're really technical, but basically the Supreme Court of Nevada did research on all 50 states and found that the New Jersey Sacro procedure made the most sense. And so they expanded Nevada case law to include that procedure, except instead of calling it Sacro, which was named after the parent who brought it to the New Jersey Supreme Court's attention, they named it Falcone, because I'm the one that brought it to the Supreme Court of Nevada's attention. Falcone v. Secretary of State. So the procedure basically allows a parent like me or any other parent who wants to come after me, who cites my case, to force the district judge who's presiding over their child custody matter to make a determination as to whether or not domestic violence has actually occurred. If domestic violence has actually occurred, then the judge has the discretion to say, no, your ex is allowed to get a fictitious address and they can keep their real address secret from you. But if domestic violence has not actually occurred, the district judge can order the Secretary of State to cancel your ex's fictitious address. Or in the alternative, they can allow them to keep it, but order your ex to actually tell you where they really live. Same effect, whatever. I don't know. In fact, I don't imagine why they would allow someone to keep a fictitious address if they're not even using it to protect against the one person they're claiming they're a victim of. So that does sound kind of weird. In my case, it was a little bit quirky what happened. Actually, let me take another step back. So because the Supreme Court of Nevada published an opinion that created a procedure that required fact-finding, the Supreme Court of Nevada was forced to deny the petition, even though it articulated a procedure that I could follow, because they themselves do not conduct fact-finding. So they cannot grant my petition for writ of mandamus and force the Secretary of State to cancel my ex's fictitious address. Instead, they created the procedure, allowing me to then take that procedure and apply it in the district court. Again, I want to reiterate, the Supreme Court and appellate courts, they're not there to conduct fact-finding. It's not what they do. If fact-finding needs to occur, it's either already happened at the trial level or they remand the matter back to the trial level. In my case, they basically denied my petition, but allowed me to refile the petition in the district court with my family judge who had been presiding over my family case. And they put all of the details in that publication to give my judge all of the instructions he would need to follow the new law that they were creating. So I did just that. I went back to the district court. I filed my petition for writ of mandamus in the judicial department of my family judge. My family judge got my petition. He read it. He looked at the Supreme Court's publication. He applied the law correctly, and he canceled, or well, he didn't cancel it. He ordered my ex to turn over her actual address to me. And then the Secretary of State themselves, of their own free will, canceled her fictitious address. So they just did that on their own. Yeah, so you can tell people here who are wondering about this whole issue of do I get to know where my ex lives, I've kind of been through the rigmarole that you would not believe, because I really just cut short my whole, there was a lot of things I left out. You know, I initially filed a petition for judicial review, which was incorrect. I appealed it, lost the appeal because I used the wrong vehicle to challenge the fictitious address, came back, used the petition for writ of mandamus. There's just a lot of things that I had to do. I stumbled around a lot. If you want to watch my video, Surviving Failures, Surviving Mistakes, watch that video and I kind of explain how I stumbled around in the beginning because I didn't know what I was doing. Even now, I sometimes question whether I do. I've won 4 appeals, but I still don't know everything about everything. I'm not even close, and I'm not sure even lawyers know anything about or everything about everything. And they've been practicing law, going into court day in, day out. So it's a tough field. There's a lot of details out there. But when it comes to this particular thing, I feel like I know a lot about it because of how I was on the front lines of the whole "where does my ex live" battle, and I had to deal with the false accusations of domestic violence, and I had to deal with judges who had no ability to help me because I had to go to the Supreme Court of Nevada because I needed a procedure to basically be created because there was no procedure in place. So again, I feel like the blame there goes with the legislature. They should have thought this through and realized that maybe exes might lie and say that they're victims and they're not really victims, but they're just, I don't know, for legislators to not know that exes lie in family court is just mind-blowing to me. For them to have not thought this through and created some kind of mechanism for a parent to challenge that whole thing. I don't understand that, but it happened in my case, and I had to go pretty much all the way to the highest court in Nevada to get that fixed, not just for myself, but for everyone after me. So I'm going to basically just summarize, yes, parents do have a right to know where their children reside. It is a fundamental right, and the reason the Supreme Court of Nevada stated that is because it gives you, the ability to have input on where your children are living, or bring it to the court's attention if it's a concern. If you don't know where your kids live, you can't, bring concerns to the court because you have no clue where they live. And it was pretty crazy. So I really encourage anyone here who has watched the video all the way to the end to take a look at the video, temporary restraining orders, or maybe I call it orders of protection or restraining orders, something like that. I'll put a card up top. And also make sure you take a look at the video on writ petitions, because I mentioned that a few times in this video, and if you haven't seen my video on writ petitions, you're going to have no clue what that is. So it's a way to challenge a district court, a different way to challenge them. It's different from the direct appeal, the ordinary appeal process. Everyone knows what the word appeal means, but not many people know what a writ petition is. It's another way to challenge a government entity, whether it's a court or whether, as in my case, it was the Secretary of State. So go ahead and post anything in the comments below. I'm looking for people who probably had this exact same thing happen to them, where their ex doesn't want to tell them where they live. And it's, some of them do it out of spite. Just because you want to know, well, too bad, I'm not going to tell you. You're dangerous. And if you also wanted to comment on the publication, if you have questions, go ahead and read the publication, Falcone v. Secretary of State. And if you have any questions, post in the comments below. For people who don't know what the difference is between an unpublished and a published order, an unpublished order resolves the issue on appeal in your case, and it controls your case going forward. But it does not help any other parents after you, or if you're not, if you're just doing a regular court case, not a child custody one. It doesn't help any other people after you. It just helps you. A published case helps you and any other person who needs to follow in your footsteps to get that same relief. So, I mean, that kind of, again, simplified it a little bit, but basically the difference is that it controls the outcome of cases after your case. The judges of the district courts in Nevada must follow the procedure in Falcone v. Secretary of State with any other parent that brings it to the district court's attention. It doesn't matter that they're not me. Other people can use my case to force their ex to tell them where they reside if they're using a fictitious address. So anyway, I guess with that, I'll go ahead and end this video, and I'll see you guys next time.